Well, hello, everybody, and thank you for joining us today. I'm Sarah Miller, and I'm the Vice President of Marketing and Strategic Communications at the Small Business Association of Michigan. And we are pleased to welcome these experts from Brooks Kushman who are here today to talk to us about cybersecurity. John Rondini is an experienced intellectual property attorney and the co-chair of Brooks Kushman's Cybersecurity and Data Privacy Practice Group. John's helped guide clients through the numerous and ever-evolving cybersecurity and privacy laws to develop policies and procedures that help prevent against breaches and for responding after a breach occurs. We also have Matt Jakubowski, a member of the firm's executive committee, and he co-chairs the firm's cybersecurity practice. Matt counsels clients in a wide range of intellectual property matters, including IP portfolio management, freedom to operate opinions, cybersecurity, litigation, agreement drafting and negotiations, and due diligence projects. Matt has extensive experience with patent, trademark, trade secret, and copyright litigation disputes. So thank you both for being with us today and enjoy the webinar.
Thank you for having us. And on behalf of Brooks Kushman, myself and Matt, we'd like to thank the Small Business Association for allowing us to present to your members today. So to kick things off, Matt and I, we're going to go through cybersecurity and data privacy, some insights for small businesses, some aspects and talking points that we've seen come up with clients, not only our smaller clients, but our larger clients as well. In particular, over the last couple of years, Matt and I, as introduced, are both the co-chairs of our cybersecurity and data privacy practice. And our practice, we started about 4 or 5 years ago as the needs of our clients started to rise in this space. So we're happy to provide some insights and share some of our findings over the last couple of years with you. So with that, I'm going to move us along here. And So to kick things off, we wanted to first talk about, just cybersecurity and data privacy in general and why businesses should care about it. Over the last roughly year, it's really grown into something that everybody's kind of become aware of. But what we tend to notice with a lot of our clients is when talking about it, they tend to go, well, we have some security measures, we have IT in place, so we don't have to worry about privacy, or we secure our privacy and we don't really need to worry about cybersecurity. And it's a common occurrence that we see where people, they have the two buckets completely separated and apart from each other, and they tend to think of them as two wholly different aspects of the equation. And truthfully, they kind of overlap in a lot of sense. It's kind of like a Venn diagram where, cybersecurity and data privacy are different circles, but they tend to overlap at some respect. And, if you're dealing somewhat with some type of data, and everybody at this point is dealing, with some type of data, there's data always coming in and out. It's just a matter of what type of data you have. That kind of plays into what type of security measures you might need to have in place. And when we counsel clients, we try to bring up the fact that while there are two ends of the spectrums and there is some overlap, there is different laws and there's different regulations and there's different agencies. And depending on what type of industry you're in, depending on what type of information you're collecting, and depending on where you're collecting it from, you could be subjected to a whole host of different types of laws and regulations, both on the cybersecurity end and on the data privacy end. And on top of that, you could be subjected to international laws, depending on whether or not you're hosting data overseas or you're collecting data from overseas, either employees, clients, or data subjects, and then transferring it, either back to the US or transferring it to another jurisdiction. So at this point, it started a couple of years ago, with some of the laws, cybersecurity laws coming up. And then about 2 or 3 years ago, every state in the US has now a data breach law. And then we started to see the European Union come out with GDPR, and that was the first really big data privacy law. Then over in California, we saw them come up with the CCPA, which we'll talk about in a second. And then we're just starting to see that, gain steam nationwide. And right now it's just all over the spectrum, depending on what you're talking about. So why should businesses care? Like I just said, cyber and data privacy, it's not just for larger companies like Facebook or health insurance company or banking companies. It's basically at this point, every company needs to have some type of, data privacy policy in place. They need to be looking at what they're collecting, what type of information is going back and forth. And this isn't just important in terms of the laws. It's also going to become very important in terms of insurance coverage, which I know we'll talk about a little bit later, but your insurance policies over the next couple of years are going to probably change dramatically. And there's going to be a lot of risk assessment that goes into the policies, into the underwriting policy portion. So this is something that if you're not on top of yet, or you're just starting to get, some steam on it, something that's going to really, really ramp up, I think, over the next 2 years, especially as insurance policies, you go back to the renewal phase and there's an underwriting phase with it. So it is definitely something that's going to definitely pick up steam. And it also picked up steam over the last year in terms of the pandemic. One of the points I have here is, last year in 2020 alone, ransomware and phishing attacks increased by over 700% from 2019. And that was largely due to, the radical and quick shift of everybody working from home. And so if we just take a look at, this slide here, it's a great slide by IAPP, and it kind of shows the different attack vectors that are out there in terms of how your system could be breached and how information from within your system could be exposed and possibly subject you to some type of a breach notification or other ramifications depending on the law. And what you see is in red here in the middle was your standard attack surface, maybe back in 2000 to 2010. You basically had a closed system where it was your corporate server. You might have had an email server. You had your workstations at the office that the employees would use, either laptop or desktop. And you might have had some other small devices like an external facing website that you hosted probably on a server in a server room somewhere at your facility. And then around 2010, things started to shift, and you had this third-party ecosystem off to the right here in the purple. And essentially what you had was you had people starting to offload and start to go to cloud storage systems for email hosting, for maybe hosting their website, maybe hosting some of their internal data. But those were typically, still some type of a closed system, but it was offsite, and it was some type of a, quasi or complete cloud system. Well, 2020 hit, and then you have the attacks, vector surface on the right, or I'm sorry, on the left. And that's in the green there. So essentially what ended up happening was, 2020 hit, everybody started working from home. And while there was employees working from home prior to the pandemic, it wasn't at the level that we saw last year. And what we really started to see as people started to plug in at home, we started to see more exposure, because as people started to use their home networks, they might not have had the security in place, or they might not have had the zero trust factor in place, or some type of VPN or other security measures in place to ensure that, devices like Alexa, your Amazon Nest or thermostats, those were all of a sudden, on the same network, might not have the same security measures that need to be in place. And we started to see, a lot more attacks happening that way. We also started to see, as people became disconnected from each other, training went way down. And so that goes back to the phishing attacks. Phishing went up, significantly last year, because with everybody working from home, they were, isolated to some degree. And so they were subjecting, email after email about either COVID related or vaccination or other information that people really wanted to have information on. They were shooting those emails out, and people were clicking on the link. So we saw just a huge wave of phishing attacks last year. And that's probably going to continue as people still continue to work from home. What we're hearing is a lot of companies are going to do some type of remote offsite working policy where maybe people don't have to come in every day. So this comes into the training aspect, that at this point, training is going to become even more important for employees, especially when they're not in the office every day. The last thing we saw over the last year was a significant increase in vendor-vendee type of attacks, especially in terms of the vendor. And this gets back to the ransomware. And last year, we probably saw the most significant vendor attack of, at least the last decade, if not ever, was the SolarWinds attack. And there, for those that aren't aware of it, it was essentially an attack where there was a ransomware that sat kind of just idle in a distribution software. And it's a common software that most companies use. Almost all Fortune 500, Fortune 100 companies use it. As you can see, the infected number was over 18,000 customers. And that number was, as of a couple of months ago, the total that was reported. So it's probably significantly higher by now, but that was, as of February, it was 18,000. But what we saw was it sat idle and it slowly just injected itself into other systems. And it wasn't until, one of the vendor, FireEye, who's, a very large cybersecurity corporation, happened to find it on their system, ironically. So it wasn't until about 4 or 5 months after the first system was infected that, this ransomware malware was finally detected. And the true extent of this vendor attack, and it was one that's just, it was passed down from SolarWinds to all the companies that use its product. It wasn't until 4 or 5 months later that it was finally discovered. So that's what we're starting to see to become a really big attack. Not only phishing, but these vendor attacks are becoming two of the biggest type of attacks that are occurring. So as I mentioned a second ago, there's a whole host of laws depending on which spectrum you're talking about, whether you're talking about cyber or data privacy. So, real quick, we wanted to go over, in terms of who enforces the cybersecurity laws and data privacy laws and how that might affect you. So, here's another slide from IAPP that, or graphic, I should say, that really shows the data privacy laws that are in place right now. And as I mentioned before, the first one in the United States was CCPA, and that was in California. 2 months ago, Virginia just out of nowhere enacted their law. It caught everybody by surprise in the industry because no one had Virginia on the map of the next state to be enacting a law. But as you can see with the color on this map, it's not going to end there. The next couple of years, you're going to just start to hear more and more laws come into play. And what that means is if you do business with anybody outside of Michigan, and Michigan at some point is going to have their own law as well. But if you do business with anybody outside of Michigan, then you have to know which one of these laws, potentially you could be subjected to and which ones you have to have on your radar. And, in terms of what you're collecting, you got to make sure you're following those laws. And the problem is none of the laws are 100% overlapping the same. Even the Virginia law that was just passed is not the same as the California CCPA law. And in terms of California, it's not the only law out there. They now have two competing laws, which we'll talk about in a second. So in terms of data privacy, all states do have a data breach law that is very similar, but in terms of what they consider to be, personally identifiable information and how it's handled, what type of requirements that you have to follow in terms of the information you're collecting and how you have to handle it, the laws are not the same, unfortunately. So as I mentioned, the first law that came on the books in the United States was the California Consumer Privacy Act, CCPA. And that came out a couple of years ago. And most people at this point are probably somewhat compliant, if not fully compliant with that law. And it has to deal with anybody that does business with any California resident. So if you collect anything from a California resident, you may be subjected to the CCPA, depending on some of the other requirements of the law. And that law became fully enacted and enforcement started to occur. Private rights of action started to occur last January. In July, the Attorney General was able to start enforcing the law and enforcing it on behalf of the states. And we started to see a lot of letters go out roughly about the middle of July to last August. So the Attorney General started to really pick it up at the end of the year because as the end of the year started to wind down, we got to election season. Unfortunately, California decided it was going to pass a new act, the CPRA, the California Privacy Rights Act. And this act is very, very more restrictive, and it cleans up a lot of the loopholes that the CCPA, that a lot of people thought had problems with. One of the most surprising things about the act, and it's probably why we saw the Attorney General action start to pick up, and we're going to start to see it even more so, is because the CPRA, it's the first law of its kind that has its own enforcement agency. The GDPR does have some type of enforcement agency, but none of the other laws here in the US have its own body that looks over and enforces the law. They just recently announced the five people that are going to be making up the agency. And they're going to be overseeing not only bringing CPRA into effect, but also any amendments to the CCPA. So they will be the enforcement body when this law fully becomes in force in just a couple of years. So it's not like this one's at like the CCPA where it's a 3 or 4 window. This one's only about a 1.5 to 2 year window. And so things are going to really pick up. So if you weren't aware of this law, this is, as of last November, and this is one that's really going to start to pick up. And there's, a lot more rights and different variations from the CCPA that the CPRA has in it. So, this is one of the laws on the book. And in terms of federal, what's out there at the federal level right now, there really isn't a federal body and there isn't a federal law in place. Right now, the closest we have is the Federal Trade Commission and their enforcement actions. And, the FTC essentially, based on information they receive, they can go after companies and enforce privacy and security regulations. And that's been upheld. It went on appeal a couple of years ago when one company challenged the FTC's ability to do this. It was upheld. The biggest thing that they can do is they can bring down, not injunctive. They can bring down fines and penalties, which is what they've done against Facebook in the past. They did it against Zoom last year, and they can leverage quite significant fines in terms of, the significance of the violations, in terms of the privacy violations and the lapses in security. So, in terms of at the federal level, this is how it's handled right now. They lay out some great policies and procedures that we've gone through with clients before. They have a 7-step plan in terms of reviewing what you have and making sure you're compliant, at least to what's called a quote unquote reasonable standard, which is what most of the laws as well as the FTC follows. And, as I mentioned, unfortunately, at the federal level right now, there really isn't an overarching federal law put in place. Right now, we have 2 competing bills between the Republican bill and the Democratic bill. And, every year it kind of comes up, but it kind of stalls out, roughly about the end of the year. And the biggest things that they can't come to agreement on is whether there should be a private right of action is one of the biggest things, and who the agency will be that will end up being the ones that does the enforcement or oversees the enforcement of the laws. Right now, they basically are looking and saying that one side says there shouldn't be a private right of action. It shouldn't be like California. The other side says it should be a private right of action, and the attorney general of a certain state should still be able to enforce it. And then the other thing is the basically who's going to enforce it. One side says FTC, one side says it should be an independent agency. So right now, that's still out there. It's hopefully with our new vice president, who was the former attorney general of the state of California and kind of really brought forth the CCPA and brought it into action. Hopefully she, takes on the burden of pushing or finally helping to get some type of federal bill in place so that instead of 50 divergent bills, we might have one federal policy that we can all follow. So flipping to the last, big topic we wanted to talk about, and this is probably the most important topic, is, as a company, what should you be doing? We have all these laws out there. We have international laws, we have state laws. We possibly at some point might have a federal law. We do have a federal agency right now. What should a company be doing? What should they be looking at? How should they start? And what we always do is we try to sit down with clients and we try to say, the best point or the best starting point that you should be looking at is, a framework, a security framework to identify not only your critical components within your system, but also what data you're collecting. And there is some great frameworks out there. Most of them are identified either at the federal level or through different laws out there as being, a quote unquote reasonable and a good place to start. The most, common one is the National Institute of Standards and Technologies, the NIST Cyber and Privacy Framework. There's also the Center for Internet Security's framework, which is also well recognized. So there's at least two, highly respected competing frameworks out there for companies to look at. They have their variances and flavors, and depending on essentially what you want to be doing and what you're looking at. NIST is right now probably a little bit ahead. Right now, they have not only a security one, they have a privacy one, which is a great thing to have. And they show, as you can see on the left here, kind of the overlap between not only their cyber framework, but their privacy framework. As I mentioned earlier, the two frameworks, or privacy and cybersecurity, is kind of like a Venn diagram. So you have a lot of overlap, and the NIST framework kind of shows that in terms of their framework, how to handle both the cyber and the privacy aspects. So that is the two frameworks that you probably want to start with. And the biggest thing you want to start with is your identification of the systems, identification of the data that you're collecting, what data is coming in and out and flowing through, who has access to it, how you're going to go about protecting it. And then on the corollary, what you're going to do to detect whether or not there's going to be a breach. And then you want to flow through your response and your recovery stages. And so in terms of the first step, the identify and protect, the first thing that we try to talk clients through what they want to do is you have to sit down and you have to classify your data. You have to sit down and know what data your organization collects, not only from customers, but also from vendors and possibly just internally. There's a couple of years ago, we saw an incident where a company had a new vendor. It was a coffee maker installation. And that was hooked up to their system, and it was, transferring data back and forth. And, that was the cause of a breach. Well, that's the type of things that you want to start looking at, not only in terms of classification of your data, but classification of what systems are connecting to your internal or external servers, how they have access, where is it coming from? So you want to make sure the first step with the data and the security, every touch point in terms of has contact with your system, and you want to make sure what data you have. And then you want to make sure what data your organization's creating. And then you want to, kind of put into the buckets, because not all aspects of your company need to have complete and unfettered access to the data. Your marketing people might not have to have the same access to data that your engineering group does. And your engineering group, maybe they don't have to have the same access. They don't need to access a lot of personal information like social security numbers most of the time. So you maybe want to lock them down and have them just have a subset of access to a certain portion of data, and so on and so forth. What we see a lot of times is we see companies just basically they have a network drive. Everybody has complete access to everything. And unfortunately, what that opens you up to, as we talked about earlier with the vectors and the work from home and everybody having access, it really subjects you to a very wide attack surface problem. And that's going to be something, again, that's going to become a really big problem in terms of insurance coverage over the next couple of years, whether or not you have locked it down, whether you have broken this down and classified your data and categorized it and limited access to certain people, whether you do know what systems are accessing your system and where the touch points all are. So in terms of the framework, in terms of first steps, that's always the first step we kind of look at is making sure we know the data, we know who has access to the data, what type of data they have access to, and who has touch points to every access point on a company's who can access the data, in terms of vendors, vendees, or internal. The next step that we kind of work through with clients is the incident response plan. And what we typically do is, once we have broken down the data and we know who has access, where the access is, and how they have access, what we want to do is we want to develop a plan, a procedure, essentially, for what to do in case there is a breach. And like I said, if you go back to, and we'll just flip back here real quick, if you go back to the NIST framework, the first thing you're talking about is identifying and protecting, and that's what we were talking about with the classification and knowing your system. The next thing you want to do is the detect, respond, and recovery. And that's really where your incident response plan comes in. Your incident response plan is there, it's set up to help you or help whoever is the contact person on a day-to-day basis, look and try to detect some type of a breach. And once a breach happens, your response plan is supposed to be your go-to plan for how to respond to it and possibly how to recover from it. And those are really critical. And it's not something you want to do, as the nice Dilbert cartoon here shows. It's not something you want to do at the time of a breach. At the time of a breach, you want to have a rock solid plan in place, knowing exactly step by step who's the first person who's supposed to be contacted. Okay, who's our outside counsel and who's our forensic examiner who's going to come in and examine, what the breach is. And one of the problems we've seen in the past is when you don't have this all in place, what people tend to do is they tend to act like the cartoon here, and maybe they send out notifications. And then, 5, 10, 15 days later, once they've done the full investigation, forensic investigation, they find out, well, the breach, while they were breached and there was a breach, maybe it was just of, employee X's, folder on his drive or on his computer that was of a couple of pictures from his kid's t-ball game. Well, if that was all that was accessed, then you really didn't need to send out breach notifications. But because you didn't have a response plan in place and you didn't go through the response plan and fully vet it out and look at it, you might have reacted prematurely, sent out these notifications, or maybe contacted the authorities when even though there was a breach, there was no breach notification necessary. So this is, a type of plan you want to sit down, get developed, work through, not only develop it and work through it, but, something you might want to test, on a biannual basis or annual basis. And then every year you want to go back through it and make sure it's up to date. It's not a plan you kind of want to just take and throw on the shelf and just forget about. So it's definitely something you want to try to keep up to date and look at yearly, maybe go through it with your external auditors, your external counsel, or if you have internal counsel, maybe go through it with them and just make sure everybody's on the same page and everybody knows who's doing what and how it's happening and who the contact people are. With that, I'm going to turn it over to Matt, who's going to talk a little bit about the cyber insurance I was mentioning earlier, and some of the aspects that it could affect you in terms of not only in terms of the incident response plan and in terms of probably your framework, but as the next couple of years, we're going to start to see cyber insurance become more important. Some areas that you may want to be aware of and keep in the back of your mind.
Thank you very much, John. As John did a nice job of reviewing and discussing incident response plans and frameworks, that's really from a technical standpoint. How can you protect your business from a cybersecurity threat? The areas that I'm going to be presenting on are more so from a legal standpoint. How can you get that next layer of protection? And they really go hand in hand from a standpoint of insurance and also contracting with your customers. There's going to be an expectation that you have a strong framework in place and that you have a strong incident response plan in place, and that it's something that you monitor on an ongoing basis and you do self-assessments. So that's really the backdrop in the context for the legal protections you can achieve through cyber insurance. So what is cyber insurance? It's a highly specialized type of liability insurance. So it's specialized in particular with respect to protecting a company against specific cyber threats and potential liability that could result from that. Since it's such a highly specialized and sophisticated area of insurance, it's evolving over time, and it's also not prone to an off-the-shelf solution. It's not like you go to your insurance provider and say, "Yeah, I want a cyber liability insurance policy," and you're going to get the same policy, and you're going to get a policy that protects your business. Since there's such a technical dimension to what's going on here in the data that you touch and in your own framework as well as your customers' systems, you really have to understand and leverage the understanding of your technical systems in negotiating the insurance policy and in making sure that you understand the right questions to ask when you're either going out and renewing a policy, getting a new policy, or self-assessing the policy that you have in place now. It's very important to understand the technical as well as legal dimensions. Now, there's different coverages that you get under the broad umbrella of cyber liability insurance, and there's coverages for protecting exposures and improper disclosures of confidential information, and in some instances, more specifically, personally identifiable information. So that's one sort of coverage that you have to look at. In each one of these coverages, you got to make sure that it suits your business and your business's needs. So when you're looking at a policy and negotiating a policy with a broker, you got to understand what types of coverages you need. Now, there's specific coverages for ransomware, for extortion, where there's access to your data, and if you don't do a certain thing, if you don't pay a certain ransom, then that data is going to be disclosed, and the data is confidential and has PII associated with it. Many policies exclude that because there's so much exposure associated with it. So that's another issue spotting area where you got to see whether that's an exclusion or not. And also these policies address the data breach response. So it's looking at the costs that are associated with addressing a data breach. Now that's your internal cost. That's going to be costs from your attorneys, as well as potential penalties and fees associated with the data breach. And there's also general forms of protection for a business interruption and restoring your data to the form it was in before the breach occurred. And one specific type of this is the business interruption coverage you have in the case of a ransomware situation. So there's many cost factors that should be looked at with respect to how much your policy is going to cost you. And in one area that they can really put yourself in a good position is show the insurance provider that you have strong security measures in place, that your infrastructure is strong, that you have the right hardware and software solutions to protect yourself against cybersecurity threats. In our line of work, and we have clients that demand a certain level of protection from cybersecurity threats in the form of software and other forms, and we have to be certified to be able to do their work. So in that case, the stronger protections you have, the better. And obviously, there's a cost component to that and putting those protections in place. But it's something at least that should be a consideration in balancing between how much you spend on your protection versus how well you do as far as what your insurance premiums are. And the trend here is that these insurance premiums are going up in this area because, as John noted, there's this tapestry of different state laws, and the federal government hasn't been able to come together and unify and harmonize the law in this area. So there's a lot of different considerations when it comes to addressing different potential liabilities here. And because of the complexity in this area of the law, it's creating higher and higher premiums. And it's, until we have that uniformity, we're going to see increases continue. At least that's what we predict. And also, you got to look at the policy and see what the exclusions are. If you have two competitive rates and one's a lot lower than the other, it might be too good to be true. So you have to keep that in mind. And John touched upon this as well, regarding the data and how you segment data within your own organization. And now I'd take that one step further. When you're contracting professional services with one of your customers, you got to understand their environment as well. And you want to segment and isolate and really limit your exposure to your customers' data to only what's absolutely necessary for purposes of you fulfilling your services under the agreement. Because that's another way that you can put yourself in a better position when you're negotiating an insurance policy, and also just limit your risk altogether. Because you don't want to be in a position where, unbeknownst to you, you've been given access to all your customers' data, which may be so much more than actually what you need. You might need only 1% of the data in their environment, but they give you complete access because that's how they run their systems. That has to be taken into account as well. So moving on to the next slide. So this goes into a little bit more detail from a different vantage point as to what these insurance policies cover. I mean, there's first party coverage and there's third party coverage. First party, it protects your company, but in the grand scheme of things, the data that you have, it's very important, but the data just by sheer volume might be many magnitudes greater with respect to your customer base. So when you're looking at these policies and going through them with your counsel, you want to make sure that you understand how you're protected if there's a breach that results in your customer losing confidentiality of their data or some other issue that arises due to a cybersecurity breach. So and that's an area where there could be a lot of gotchas as well as limitations on the coverages and the policies. So it's not, it may look like a great policy from a first party standpoint, but you want to dig deeper and look at the third party protections, and you want to make sure that from a legal standpoint and what you have in your insurance policy that really shadows and mirrors the type of access to the data that you're gonna have when you're fulfilling your customer contracts. So that's a very important thing too, and I'll stress again that you want to limit your exposure to a customer's data as much as possible, and that'll help you for a whole litany of reasons. Another area where we commonly see exclusions or limitations in these policies is they could have the insurance company saying, well, we're going to select a response team for you. So there's a breach, we use this response team, and maybe there's economies of scale there that the insurance company uses the same response team and they give them a better volume discount, but that may not be in your company's best interest, that the insurance company is selecting the response team for you. You may want to select a response team based specifically on the type of cyber security threat or breach that you experienced. And since this is highly specialized, there may be a response team that's better from that standpoint. Also, insurance companies typically look at cyber war clauses to try to carve out certain protections and coverages in trying to make a breach into something that's a nation state of attack. And so you want to, that's gotcha language too that you want to look at, and to the extent you can limit that or eliminate it, you're better off. Now, as somewhat of a second resort, if you're in a situation where you need to leverage your cyber liability insurance policy and there's some question as to coverage, there's other sources to look at to determine whether there's potential coverage. And this shouldn't be the first step, but in case there's some issues with coverage, then you can look at these other policies. There could be a policy that's got an errors and omissions clause that covers potential cybersecurity breach. There's also employment practice policies that should be looked at as well in the context of determining what the coverages may be in this type of situation, and also some of the policies, professional liability policies, could be used to find coverage for ransomware if there's a kidnap ransom policy that's part of another one of your insurance policies. So that's not the first resort. It's probably the last resort in some cases, but it's also something to think about when you're attempting to identify and determine coverages. So moving to the next slide, we're going to toggle back over to John. He's going to handle that slide, and then I'm going to go through some contractual considerations with respect to cybersecurity issues.
Thanks, Matt. So real quick, I just wanted to touch on the fact that about 2 months ago, in terms of not only, and that's why this is kind of a transition slide, it fits in here. It's it's not only a transition in terms of insurance, but also in terms of contractual considerations that you may want to think about. Because 2 months ago, New York, the Department of Financial Services, they enacted the Cybersecurity Insurance Risk Framework for insurance companies out there. And basically, it's essentially a 7-point framework for insurance companies, going through the underwriting process to kind of vet and look at companies that they are providing insurance for in terms of cybersecurity and data privacy. And it's something I think we're going to start to see, as I mentioned earlier, in terms of insurance and in terms of what Matt just went through with not only first and third party coverage, but just coverage in general. You're going to see insurance companies, as well as probably, companies in terms of who they're selecting as vendors, start to implement these risk frameworks, and they're going to start going through them and start to evaluate what type of risk a potential company may have in terms of not only insurance, but if there's already talks about risk frameworks in terms of, like I said, vendor-vendee type contracting. And that's going to be something that you're going to see larger companies requiring of smaller and medium-sized businesses. And you're going to see insurance companies requiring that of all businesses, essentially. It's going to be something you're going to have to go through. I would equate it to a type of audit, which I'm sure most of you have probably had some interaction with dealing with other companies. You might have been requested to fill out an audit form or go through and fill out a survey, essentially laying out certain aspects of your security and what type of privacy or data that you collect. This is going to probably be more formal, and it's going to be probably way more in depth in terms of the type of audits, the type of risk that they're going to provide insurance for, what type of coverage you may be allowed to have, and how much the coverage may, equate to. And that's going to become a big concern area when you start to try to go out and get new business. And as Matt was just talking about, and this will be something he'll talk about in his contractual considerations, when you're dealing with these contracts with other companies, there's going to be the addendums, there's going to be the insurance clause in a contract. And if you can't get the right coverage from your insurance provider, and you go to contract with another company to do business with them, and they require you to have $20 million of cyber, that seems very high, but I'm just throwing that number out there, $20 million of coverage in terms of cyber, not anything else, not any, business aspect. I'm just talking about cyber. And you can't get that because the, insurance risk framework puts you in a high category because you don't have the right cybersecurity framework in place. You do not have a framework in place. You might not have an incident response plan, or it's lacking. So your premium, it's kind of like a pre-existing condition right now, type of problem. If you don't correct it now, it may become a pre-existing, and your insurance premiums and coverage, your coverage might be lower, but your premiums might be higher. So this framework is something that if you're not aware of it, it's something you probably should look at or talk to somebody about, because it's something you're going to want to start looking at, reviewing, and making sure that you're on top of it. Because when these policies start to come due in the next couple of years, especially after the pandemic we're just coming out of in 2020, we're going to see premiums and coverage really dramatically change, because insurance companies have definitely taken a hit in terms of the ransomware. Ransomware has just doubled in terms of 2019 to 2020. The demands from ransomware, it doubled again between 2020 and 2021. So we're seeing ransomware costs go up. Insurance coverage usually protects and covers that, as Matt just explained, but it's going to be a problem, and there might not cover it moving forward if your framework is not sufficiently, or I'm sorry, not the framework, if you are considered in the risk framework to be of a category that they don't want to protect. So it's just something that you should be aware of, and you should be on top of, and make sure that if you're not aware of it, you talk to somebody about it, because it is definitely something over the next couple of years it's going to become very important. With that, I'm going to turn it back over to Matt so he can talk a little bit more about contractual considerations.
So top level considerations here is you often get a agreement, a master service agreement from a customer, especially if it's a larger organization where they want you to sign the agreement. It could be 30, 40 pages long. And from a cybersecurity standpoint, the representations and warranties could go on for pages with respect to data privacy and data security, and how your systems and your IT has to be set up. So it's if it's not something that's being reviewed, you could be obligating yourself to these technical requirements that your system's just not set up to do. So you got to be very careful. It's better off in many instances to have a minimum standard of care from a legal standpoint, then it's a reasonableness standard, and you have more flexibility with respect to if there's ever an issue with your customer from a private contractual standpoint. You can say, well, under the circumstances, I've acted reasonably here. So if that can be substituted for a laundry list of different representations and warranties as to technologically speaking how your systems are set up, you're much better off. And also you have to look at the indemnification provisions. Oftentimes, if you fail to live up to a representation warranty that you make in the agreement, then the indemnification provision is triggered. So it could be a very technical breach of a rep and warranty, but it could trigger a scope of indemnification that's very broad. And also with respect to indemnification, you really got to match it up with your insurance policy. You don't want to take indemnification obligations on that you don't have protection from your insurance policy. And also you have to take into context what the supply chain considerations are. Are you basically modifying somebody else's product? You want to make sure that you don't have any obligation with respect to their product in a potential breach related to their product, that it's very specific and narrow to what you're adding to the equation. So supply chain considerations are very important. You don't want to take on somebody else's liability, and you want to make sure that it's very focused and limited to what the liability should be with respect to what you're adding, the services you're providing. So we'll go to the last slide here. I know we're running low on time. Now this one, the managing the customer relationships, and part of that's the negotiation in contracting process, but also, I mean, once you have a contract in place, you've done all your pre-contracting due diligence, you've done your negotiation, you have a good agreement in place. It's one that you can abide by because you have the proper technical safeguards in place. This is an ongoing thing. You want to make sure that you monitor your ongoing relationship. You want to make sure that creep doesn't happen where you end up getting access to a bunch of data that you don't need access to. And that's really important to look at this over time. So think of it as something that is part of your process, bake it in, that you reevaluate the relationship every so often on a periodic basis to do self-assessments and understand where you're at. And this will help as far as showing your customer that you're being reasonable if there is ever an issue that arises, as well as from an insurance standpoint and premium standpoint, that you're doing everything in your power. And it's more difficult for an insurance company to come back and say, hey, this is excluded from your policy because you did something out of bounds with respect to the policy. We don't think we can cover you. So with that, that's our last slide. And I think we're almost out of time. So I'll turn it back over to SBAM and Sarah.
Well, yes, thank you both so much. I know that this is such an important topic to cover, one that we at SBAM have been trying to be very involved in raising awareness for our members. I didn't see any questions come in that hadn't been answered during the conversation. So I think we are all set now. What I will do is send out the slides to those of you who are participating today. And we do have time for maybe one question if one comes in on the chat, but otherwise I might just say thank you both very much. And while we're waiting to see if a question comes in, I will let you know that Brooks Kushman is hosting another webinar on May 12th on trade secrets. So please be sure to register for that. SBAM also has a Future of Work series coming up starting next week with Consumers Credit Union. We have an energy efficiency virtual event in May as well. And of course, if you are so inclined, you can tune in to our small business briefing here in just about 10 minutes. So we'll be back on Zoom or on Facebook. So John and Matt, I want to say thank you. That was really informative. We appreciate your time and the work that you do in helping small business owners navigate this.
You're very welcome. Thank you for having us.
All right. Thanks, everyone.
Thank
Have
you.
a great day.
Thank you. You too.
Bye-bye.